When he was sacked, they argue that due process was not respected to have expelled him from the ruling All People's Congress Party, which was a precursor for his eventual sacking as vice president of the country. The application also details what the lawyers say were violations of the rights to protection, personal safety and security, due process, as well as participation in government and even the dignity of Sumana. All they say are injurious and traumatic for their clients.
Injurious and traumatic to the tune of $200 million?
Exactly, that's what they are saying. They say that the trauma, the psychological problem he had to go through, they subjected him and his wife to those very challenging times. They say when armed soldiers went to the house, according to their clients, they sacked vice president in this case. All of that plus the legal cost, they say their clients should be compensated about $210 million, in fact.
So what has the government said about this?
Well, the Attorney General and Minister of Justice, Joseph Kamara, says they have been notified about the matter by the ECOWAS court, but that they are yet to receive the document, hence they cannot comment on it. However, he says that they are, in his words, willing and ready to defend the action of the president to have sacked his vice president anytime, anywhere. And if the state makes a representation, which Joseph Kamara, the Attorney General, says they will, it will be the first time Sierra Leone has done so, at least under the presidency of Ernest Bai Koroma. Two cases in recent times have been taken to the ECOWAS court against the state of Sierra Leone, and on both occasions, the state did not represent itself, did not put in any representation, but in which case they lost by default.
So why has this case gone to the ECOWAS court? Couldn't it have been handled as a labor dispute?
In the views of the lawyers representing Sumana, he was not able to get the redress they say he ought to have gotten here. The Supreme Court, mind you, ruled in this matter in favor of the president, but they argue that their client was not able to fully and adequately represent himself and put his cases really well. There was a point when Sumana had to fire his attorney because in his views he did what Sumana had not advised him to do. So there were a lot of wranglings in court, but eventually the court ruled, and that court is a constitutional court, and the final court ruled in support of the president. Therefore, they say that there is no local remedy available, hence they have taken to the regional ECOWAS court.
So should the regional court at ECOWAS rule in favor of the sacked vice president, do you think that the government would respect the ruling?
ECOWAS court decisions are morally binding, not legally binding. But in Sierra Leone, the two recent cases, the government obliged in the case of one, when a Lebanese businessman sued the state for a very controversial contract of supplying some gunboats during the country's civil war. The government respected that. However, in the case of a police officer who sued the state for his unlawful dismissal, as he thought, from the force, won the case by default because the state did not put in a representation. He is based in London. He has still not been paid what the ECOWAS court said he must be paid by the state of Sierra Leone.
Sumana reporting there from